Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello, welcome to podcast number 136, and we've got 3 cases to get through, and as long-term listeners will know, it's also summer is festival season. Indeed, I learnt this week that one of my friends now refers to me at his home as Festival Nick, which I have to say I quite like. Maybe I'm going to start adopting that, sign out my letters on that. Anyway, I have a report as well from one of my first music festivals of the season. The 3 cases we're looking at cover compensation for a discrimination case, how PHI affects that calculation. We've got a case on the perils for an employer accessing an employee's iPhone looking for corporate information, and a case on disability-related absence and how employers should treat prolonged absence for disability reasons. As always, please don't forget you can access the podcast through the Mayor Brown website, LinkedIn, it's on iTunes, YouTube, and we post out all the links for the cases on Twitter at Nicholas ROBER11. So, first case, Colt Technology Services Limited and Mr. J.B. Brown. Lots of employers have flexible benefit schemes, and in many ways the issues these raise are predominantly contractual ones. Is the drafting clear enough? Does the employer retain flexibility to alter benefits on a year-to-year basis? What's the default option, etc.? But every now and again they throw up issues which employers need to take into account when constructing these arrangements, and this is one such case. The background here is that Mr. Brown, the claimant, won a claim against his employer for harassment and discrimination and a failure to make reasonable adjustments. The tribunal went on to order a remedies hearing, and that's where things started to get more interesting. In a break from tradition, let me start with the law and then explain how it all fitted together with this case. It's well established if an employer pays for the premium for an insurance policy for the employee, and that insurance policy then pays out for the employer can take those insurance policy payouts into account in reducing the level of damages. So, for example, for a permanent health insurance policy, a PHI policy, paid for by the employer, if the employee is out of work, would be entitled to damages for lost wages for that period, but the employee has received payments under the employer's PHI policy in respect of lost income, then that operates to reduce the claim against the employer. On the other hand, if the employee takes out a private insurance policy in respect of lost wages, then the employer is not entitled to rely on those insurance payouts because those are payments earned and paid for by the employee, not the employer. In other words, it would be unfair to the employee to deprive them of a damages claim just because the employee had been prudent enough to take out some insurance. Now that much is clear-cut. In the Gacka and Pirelli case, the court accepted that if there was a group insurance policy and the employer paid the premiums, then that was an employer policy and so the employer could effectively offset the payments. However, it was also accepted there was an exception to this rule. If the employee had paid or contributed to the premiums, quote, directly or indirectly, then this was akin to an employee paid for policy. It was not enough, however, the Court of Appeal said that the employee earned the policy by working for the employer. There actually needed to be some sort of contribution to the premium. Okay, all clear? Well, what happened here is that there was a flexible benefit scheme. Part of the benefit was that the employee was automatically enrolled into the PHI scheme. The minimum cover was 50% of salary protection. However, the employee could have up to 75% cover. If the employee did nothing, he was automatically enrolled at 75% cover. But the employee could choose to go down to 50% cover, in which case the employee would receive higher salary payments. In other words, by foregoing some of the PHI cover, the employee would get some cash in his hand. Here, whilst the claimant did make changes for other parts of the flexible benefits on offer to him, he took no action in relation to the PHI. Therefore, cover was automatically entered at 75% and he automatically did not receive a higher salary. Which side of the line was this? Did the employer get to offset all of the PHI payments, 75%, or just 50%? The Employment Tribunal and the EAT both agreed. Although counsel for the company tried valiantly to argue otherwise, the court said that in essence there was no difference between electing to have the enhanced cover of 75% and foregoing pay on the one hand, and paying for the enhanced cover and reducing salary. Therefore, in the view of both the Employment Tribunal and the EAT, the employee's damages were reduced by 50%, the basic irreducible minimum PHI policy provided by the employer, but it was not reduced by 75% because the employee had, in effect, paid for that additional cover. Counsel for the employer argued strongly that the employee was simply choosing from a menu of benefits, all of which were provided by the employer. Therefore, it would be absurd to permit the employee to get the benefit of 25% of the PHI policy without offset against the damages claim, when in reality, the employee hadn't paid for anything. The court didn't agree, and on these facts, I have to say I think I tend to side with the Employment Tribunal and the EAT. The employee was giving up a cash benefit to get 75% cover. The fact that the 75% cover was the default option, albeit not the minimum option, I don't think alters the nature of the bargain. The employee was offered the choice of more cash or more PHI cover, took the more PHI cover option, and therefore was giving up the more cash. That's not really that different from the employee spent some cash getting the enhanced PHI cover. For me, however, the more interesting question is this. If there's no cash option and the employee was simply allocated, let's say, a sum equivalent to, £8,000 to spend on a flexible benefits policy, and in that the employee could take out enhanced PHI cover and have, say, less holiday, would a court view that as contributing directly or indirectly? If that becomes the case, if an employee is contributing indirectly to the enhanced PHI cover by giving up some holiday or by investing some money allocated by the employer towards benefits, if we get to that point, then I can see the flexible benefits policies may have a hidden catch for employers. Or, to put it another way, employers may want to insist on a higher minimum PHI cover as part of the flexible benefits, so they can offset those payments if an employee is able to make a PHI claim and is also claiming damages against the company. So, as far as this case goes, I think it's one for employers to be aware of, and they may well be able to offset the benefits of a PHI policy, but, on the other hand, employees will need to be aware of it because the value of their damages claims may be higher than they originally thought. So, that's the case of Colt Technology Services Limited and Brown. Next up, Mark Richmond and Selecta, which is SELECTA Systems Limited. This is a High Court decision dealing with a damages claim by a former employee against the former employer and a counterclaim by the employer against the former employee. There's quite a lot going on in this case, and factually I'm only going to touch on a couple of points, but the gist of it was that the employee, Richmond, had worked for Selecta for a number of years. However, for various reasons, the company decided it was time for him to be moved on. And there were some discussions between the parties. No documents were signed, but terms were discussed. Arising out of that, the individual took the view that there was a concluded and binding settlement agreement. The company took a different view. But the employee held on to the company car, claiming that it had been agreed that it was going to be transferred to him, and the company sued him to recover it. And the court, as the first issue, was asked to determine whether the two parties, negotiating directly with each other, had in fact come to a final landing and a concluded verbal agreement. Court's view was that this had not happened, and obviously this was based heavily on an analysis of the particular factual situation. But it's striking the court accepted evidence the company had not paid anyone out on leaving other than against a signature on an appropriate settlement agreement. And here the court accepted that the company's intention when it was making the offers was and was always known to be that this would be fully recorded in writing before it became binding. So, first point to make clear is that where there are discussions between parties, particularly without lawyers being involved, it's always essential to be clear about the status of an offer that is being made. If one side or other say yes to the offer, is a binding deal created at that point? Remember, of course, that for a contract to be formed, you don't need to have a document in writing. A verbal contract's as good as anything else. You wouldn't have a binding settlement agreement, statutory settlement agreement, but that's a slightly different point. If you don't want there to be a binding settlement agreement, a binding agreement when the other side say yes to the offer you've made, then you need to be very clear the agreement is subject to the conclusion of a written document. Here, as a result, the court accepted there was no severance agreement and the individual had to return the company car. However, the other point that came up was a slightly different issue. The company took back possession of an iPhone that had been provided to the individual by the company for business use. There was no prohibition on the individual using the company iPhone for reasonable personal use. The company, when it took the phone back, searched to see whether there was evidence that company data had been retained on the phone. And the the company looked at the phone itself rather than getting specialist outside help, and I'll tell you why I mention that in a second. But the director, looking at the phone on behalf of the company, accessed the claimant's personal social media accounts through the phone to check for company information and deleted some customer contact information that he found. But to do so, he had to alter the passwords for the accounts. The court accepted the company was entitled to protect its business and its business interests by accessing the phone to discover whether there was company information on the phone. It was permitted to delete that information. It was also, in the court's view, acceptable for the company to see if such information had been stored in the claimant's social media accounts, his iCloud account, for example, and delete the information there too. However, the problem was that in deleting it, or in order to delete it, the company had altered important security details of the internet accounts, and those internet accounts actually belonged to the claimant. The company was not authorised to make those changes merely because the claimant had given his password details to the company when requested to do so. The company had gone ahead and taken steps which affected the claimant's use of his personal internet accounts, things like iTunes, and they were lost as a result. The court accepted this was a negligent act by the company, and therefore they were in breach of the duty of care that they owed to the claimant. The company tried to defend its actions by pointing out there had been a way for the claimant to recover those accounts. If the claimant had been able to remember the postcode for the house he'd been living at the time when the phone was ordered, he would have been able to retrieve the account's information. The company claimed it could not be liable to the claimant, given that an essential chain in the loss was the claimant's own failure of memory. However, the court did not accept this. It was the defendant's actions which had placed the claimant in that situation. It's not unusual for people to forget passwords, and therefore the company was responsible for the loss of the accounts. And the court awarded £1,000 in damages. I thought it was an interesting case on a point which obviously doesn't come up very often, and clearly the measure of damages in this case was not significant, but potentially you can see that other and more significant damages could be awarded. I do wonder whether post-GDPR we might have seen a different type of claim. Anyway, I think it's interesting the court accepted that the company was entitled to access the claimant's own iPhone accounts and iCloud storage facility to see what was stored there, having been provided with the passwords by the individual. Note, this was not a hack by the company in any sense. The individual provided his passwords. However, where the company went too far in altering the security settings and then being unable to alter them back, thereby depriving the claimant of his accounts, that gave rise to damages. I think the real moral of this is that it's probably better to pay a specialist to look at the iPhone and do the searching than to risk a negligence claim if you inadvertently harm the claimant's legitimate personal social media accounts. Also, in my experience, it's often quite difficult to know exactly where material is stored, and I think specialists are much better at finding that stuff without trampling all over the evidence or the personal accounts of the individual. So that's Richmond and Selector. Next up, DL Insurance Services Limited and O'Connor. This case concerned an appeal by the employer against a finding by the Employment Tribunal that it had discriminated against the employee contrary to Section 15 of the Equality Act 2010. That section, as you remember, prohibits an employer from discriminating against an individual by treating him or her unfavourably because of something arising in consequence of her disability. It is, of course, a defence if the employer can show that this treatment, which did happen, was a proportionate means of achieving a legitimate aim. Here, the claimant was disabled and was known to the employer to be disabled. She was given a 12-month written warning for being absent because of sickness. She was 6 times over the trigger point in the respondent's sickness absence policy. But the claimant asserted the warning amounted to unlawful discrimination contrary to Section 15. The claimant had been employed since 2005 in a customer support role. There was a sickness absence policy at the employer which acknowledged that disciplinary action could follow in certain circumstances, and the purpose of the policy was stated to be early recognition of health issues and to help manage absence. Excessive absence, according to the policy, would be identified and managed as soon as possible. Managers were advised to contact occupational health when deciding how to manage a capability issue, and it could be key evidence, it was said, in a claim to an employment tribunal. The policy advised managers generally to get medical advice from Occ Health before taking any action against an employee who was absent due to a medical condition. Here, in 2013 and in 2014, the claimant had had significant periods of absence. This was treated informally by the company, but she was told if a sickness and absence did not improve, the respondent would consider taking further action. In March 2016, she was told that the company was going to start a disciplinary procedure against her in relation to the level of her absence during the last 12 months, which totaled 60 days at that point. At the disciplinary hearing, the employer was asked, but did not answer, why the matter had not been referred to Occ Health before the disciplinary process was started. Anyway, the outcome of the disciplinary was to give the claimant a written warning for 12 months. This in turn meant that the claimant's sick pay was suspended. The decision maker accepted, during the hearing, that the absences were genuine and the claimant had no control over them. When asked by the Employment Tribunal why issuing a written warning would assist in the circumstances, the manager said it was generally her experience that the issue of a warning and the suspension of sick pay, quote, dramatically improved, unquote, attendance levels. And so say all of us, of course. Well, looked at from a legal perspective, the Employment Tribunal accepted that the claimant had been treated adversely because of something arising from her disability. This was not challenged in the EAT, nor could it be. It was therefore up to the employer to identify a legitimate aim, which was, here, according to the company, to ensure adequate attendance levels for staff. The purpose of the warning was to improve the claimant's attendance levels, according to the evidence. Although the Tribunal and the EAT accepted that the employer had adopted a very careful approach and treated the claimant with great sensitivity and sympathy, this was not sufficient here. The respondent could not show the treatment, i.e. giving the written warning, was a proportionate means of achieving a legitimate aim, because the employer didn't produce sufficient evidence to show that it would produce adequate attendance. In addition, it had breached its own policy, which talked of the need for Occ Health review before any action was taken. The EAT and the Tribunal found that the witnesses' statements on the benefit of issuing a written warning were generalisations and did not satisfy the Tribunal that the warning would have the effect which the employer had intended. As such, the appeal was unsuccessful. And just passing there, it was unfortunate for the employer. The claimant's attendance did improve significantly after the written warning was given, and you might have thought that that would allow some evidence to show, look, this is what happened. But unfortunately, the claimant also moved into a different job at that point, and so the evidential benefit was lost entirely. Stepping back, clearly this case may cause some concern for employers. An employee who over many years has had significant issues and has significant enhanced sickness absences is able to bring a damages claim when the employer has merely issued the employee with a written warning. However, I think it does require an employer to focus, perhaps more than the company in this case was able to do so, on the reason why a written warning was appropriate. The EAT noted the employer had simply said that the warning was to improve the claimant's attendance levels. EAT also noted the company had not argued there was any other legitimate aim in play and gave the examples of deterring absences by making it financially disadvantageous to the employee because sick pay would be suspended, or to enable the respondent to take the case to a disciplinary procedure so that if attendance did not improve further, eventually it would be able to dismiss an employee who had a poor record of absences fairly. In short, here the employer had said that the sole reason was to improve attendance, but once it was accepted that the employee's absence was genuine and she had no control over her absences, it was obviously difficult to see how a written warning would assist that. In the circumstances, I think it would be appropriate for a company to tread carefully in this area. Clearly, to give someone a written warning for something that is not their fault feels counterintuitive. Equally, and I think this is what the EAT was hinting at, it would be potentially acceptable to say to the employee that the level of absence is pushing the employee towards a managed exit. A fair procedure, of course, requires an employee to be given advance indication that the employer is thinking of moving in that direction. That's really what a written warning, final written warning system is all about. I don't think this case means that employees are entitled to have endless amounts of time on sick leave if they're disabled. But I do think it's important for an employer to be clear about why it is acting, given that it needs to be able to justify objectively that what it is doing is a proportionate means of achieving a legitimate objective. And of course, the trouble with calling something a written warning is it has disciplinary connotations that are often usually tied in with the employee has done something wrong. And of course, if the employee can't help their absence, then that's obviously an unfortunate connotation. Okay, so that's the case of DL Insurance Services Limited and O'Connor. So thank you very much indeed for listening. I hope to be able to come back to you within the next couple of weeks with a guest podcast, a special episode coming up with an exciting special guest coming in to talk to us. But in the meantime, I said I'd been off to a music festival. I went to the Killin Music Festival, which Killin is a small town north of Perth in Scotland, and a friend of mine was helping to organise the music festival. And I'm sure in an entirely legitimate way of ensuring these things happened, his band, Mocking Dogs, was also booked to play. So I suspect this is the first time Mocking Dogs have been given a shout out in an employment law podcast in England and Wales. But there we go. The other band, they were very good, but the other band who were also very good and who were second from the top on the night I saw them. If you like fiddle music, can I recommend a band called Mech Lear? And I don't know how you pronounce it, but I know how you spell it. MEC, new word, LIR. Absolutely fantastic live. Really, really good stuff. And the album, I bought the album, it's great. So if either I'm going to come back in a couple of weeks with a guest podcast, or it'll be episode 137 coupled with a report, wait for it, on the Lake Trasimeno Music Festival, because I'm out on holiday in Italy next week, and we're off to see the music festival while we're out there. So I bet you can't wait to hear how that goes. Until then, stay safe, take care, bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.